Have you here live Thursday night from the SCC studios in White Bear Lake. We're also live in over SPNN in St. Paul. And, you know, Michelle MacDonald got convicted this last week, she was sentenced on Wednesday. And we're going to go over that hearing and show a press conference that I was the only one. Well, actually, two people showed up for that. Only one with a camera. Had to be outside in the cold doing that press conference because you can't allow cameras in the courtroom. Or did Dakota County change their policy recently? I'm trying to figure that out. But you still can't have them in the courtroom. So we're going to talk about that. It's fascinating what's going on, and people need to understand what's going on because with the articles that came out, Michelle MacDonald, Star Tribune, Michael Broadcor's article in the Star Tribune also, and the blogs, and Pioneer Press had an article. And so just, you know, what they say in the press, with the press, is if you don't read the press, you're uninformed. If you read the press, you're misinformed. Probably goes true for this show. You're not as informed as you can totally be. There's just a lot of details that go on and in these cases. So you're going to see the most detailed information on this show. You won't get it in the printed press. This show was the only one that brought you the arrest videos, which, Nathan, if you're still in the control room, I'm going to have you, oh boy. I know what I'll do. I'll do it at another time. I forgot to put in the showing her getting pulled over because it's an integral part of Michelle MacDonald's sentencing that they had her try to do something, take a class that in no imaginable way does she need to take this class. And there was much more to that, but we'll get into that in a bit. The main thing, before we get into Michelle MacDonald and the sentencing and what went on before, after, and in between, is I want to focus here. Unfortunately, a man in Maplewood was killed last Wednesday morning, and it was in a bar at the Tiki restaurant down on Rice Street, 40-year-old man, and he was there with his daughter, who was, I believe, around 18 years. And anyway, what the press originally reported, and I got the new article here, and I couldn't see it's been changed, but in the original article, it said that one man was speaking really loudly, probably swearing a lot on his cell phone. A couple men said, "Hey, please keep it down." And one of these men that said, "Please keep it down," was this Eduardo Figueroa. And evidently, 200 people showed up at his vigil or more that night. A well-respected man. Just gave his life to people. Anyway, he ended up getting beaten up, but what was in the original article that is not, that I can tell in the newer article is, well, here, it is here. They give the facts here according to the witnesses. Later the evening, after these two men said, "Hey, there's keep it down," these two men were then approached approached Figueroa, flanked by another man and a woman. So there was two men and a woman. One of them asked, "Who do you expletive do you think you are?" Then his daughter, Figueroa's daughter, stepped forward and was assaulted by the woman. Okay. The woman assaulted Figueroa's daughter, so he stepped in and then ended up being knocked to the floor and was just kicked repeatedly over and over and over, died, and then he later died of his injuries. The point I want to make here is that I've been before the Maplewood City Council, I've been before the legislature, been before various places, and this cannot go unnoticed. And it was the woman who initiated the assault, okay? And I cited a study done by a doctoral educated woman in statistics and abuse who did a study and said if women didn't initiate violence, they wouldn't be as abused as much. But what happens when these women initiate violence, they expect their men to step in and then defend them. And what happens, men end up being abused or killed. The same thing happened to Ray Woodstrand, the employee here of the studios in SCC. He was walking near his home, and there was a bunch of people outside. Two girls started a fight, and one got knocked to the ground, according to reports. He gave a hand to help up, try to help calm the situation, and then 3 to 4 other men, because I consider anybody over 16 years old a man. They should be a man. Our society should expect 16-year-olds to behave like men. Beat him, gave him severe brain damage, almost killed him, but thank God he's recovered. He's back working here part-time at the studios. A long, long process, and it's been over a year ago since this happened, but now he's back, can only work part-time, still has effects of the beating, but it was initiated by women. And this is what the domestic violence industry wants to ignore. They don't want to talk about it. This is the big elephant in the room, women's behavior and how it affects domestic violence, not only amongst themselves, but amongst men. And actually, in my opinion, they really don't care whether men are abused or not. And that's too bad, because if you're that Ray Woodstrand, if you're this Eduardo Figueroa, and you're family members with these men, it affects not only the men, it affects the women in those families severely. So I guess if you really want to look at it, the men being abused is also abuse against women, and because it affects those families and the women that are associated in their lives. I want Officer Schnell, Police Chief Schnell of Maplewood City Council, to bring charges, criminal charges, against this lady that assaulted the daughter, because she started it. And it needs to be done, and a message needs to be sent. And maybe St. Paul then will bring charges against those 2 women who started that attack. And as far as I know, they haven't. Bring charges against those women who started the fight, and that ended up with Ray Woodstrand being beaten up. This is tragic. Come on, domestic violence industry, step up to the plate. By you being silent and by not stepping up to the plate, you're part of the abuse. You're the abuser too, then, in these situations. So let's get it together. Second issue I want to cover before we get into the Michelle MacDonald sentencing for obstructing the legal process and failure to take the test, is that there is in the Minnesota Athletic Association League still the December 4th hearing on whether they're going to allow the athletes themselves choose their sex gender, and therefore if I'm a boy and I choose to be a woman, then I get to go and shower in the women's locker room, and vice versa. If I'm a girl, I get to go shower in the boys. And testimony was taken that in other states where they have this policy, these type of things are happening. And it's all based upon the student's desire. This is a really, really bad policy. This is something that the LGBT groups are supporting and have as part of their agenda to be in your face. And what's happening, LGBT, they call themselves queer. They're the queer organization. That's the name they call themselves. So that's not a rant on them. That's just what they call themselves. But this is a policy they're pushing, and parents, this affects every single child in Minnesota. You may think I have my kids in a private school. It doesn't matter. I homeschool my kids. It doesn't matter. They're coming in and they're taking over, and we're going to have a show on this down the road. But I just wanted to remind you to be aware. CPLaction.org or com. Go to that website, get more information. Don't drown this out of your memory. This was stopped. They tabled the discussion till December 4th, Christmas time. People be too busy to pay attention. You can't do it. That's why it's so important to get the right people in these elected positions, because they appoint people to these unelected positions, and then they start making policies, and it just goes downhill from there. So I just wanted to keep that in mind for you. All right, Michelle MacDonald. We've shown the videos of her arrest. We're going to show the video again of her pullover, but I forgot to load that, just warning you, Nathan, so I'll help you when we go watch this next clip. But there was just some fascinating things that happened in her sentencing. And the first thing you need to know is that Michelle MacDonald is going to appeal just a lot of aspects of this hearing. And she should. And if you saw the arrest video, if you saw the pullover, you're going to go, what are these police officers thinking? She wasn't doing anything wrong, except for the aspect that people think that if a police officer tells you to do something, you have to do it. And that is not true. It depends on what it is. But the police officers, prosecutors have been trying, and the courts have been trying to blur that line for a long, long, long time so that the people don't know. So where we've actually come upon is now, if people don't stand up, where we have a police state. And we have a judge in Dakota County, Leslie Metzen, that supports that police state, that it just doesn't matter what you do, whether there's reason or not. If you don't do what a police officer says, you're obstructing the legal process. And so it's important that Michelle MacDonald, who ran for the Minnesota Supreme Court, wins these and fights for your rights. But that's the person she is. She's fighting for your rights. So we got our first press conference here coming up, first part. And basically what happened is Stephen Grigsby, the attorney for Michelle MacDonald, he comes out, does this little press conference for me. Nobody else was around. And you're going to hear what he has to say now about some of the appeals and what's going on next.
Count the relevant factors and imposed what I thought was a fair sentence given the nature of the conviction. But in the end, we're seeking a vindication with the Court of Appeals on the 2 counts she was convicted of, not the speeding. And the basis for the appeal is that the refusal instructions didn't adequately state a coherent theory of law under the Constitution, and that you can be completely innocent and still be convicted of refusal. The other count, the obstructing legal process, it's so comprehensive that a person can be found guilty of obstructing legal process by the assertion of a validly recognized constitutional right, which is, I think, what happened in this case too. Other jurisdictions provide some insight on the nature of the absurdity of the Minnesota statute by suggesting that by affecting in their jurisprudence what the statute actually says, which is that there has to be the performance of a lawful duty. For some reason, the jurisprudence in this jurisdiction has disregarded that important qualifier put forward by the legislature in interpreting it to mean essentially that even if the police officers are neither performing a duty or whether if that duty that they're performing is unlawful. Now, I don't think you can. It can't be a duty to do something unlawful, but the lawful requirement is essentially what's at issue in the appeal. I think both of these statutes are overbroad and unconstitutional.
Have them raising the key questions in this. Do you have a duty to do whatever a police officer says? Is there a jurisdictional element that a police officer can't tell you to do things in a lot of situations? If you're walking down the street, he's got no basis to be talking to you. Can he pull you, stop you, take your name? He's got to have a reason, a lawful reason to stop you. And in this case, when they were asking Michelle MacDonald to get out of the car, and she refused, but she refused because they didn't have a lawful reason to have her get out of the car. And a slight smell of alcohol doesn't do it in this situation. So obstructing the legal process, how can you be obstructing a legal process when something isn't illegal? You know, they can say it's illegal or what you're doing is illegal, but if it isn't, and you're an attorney, you know the law, you know it's not, you're under no obligation to do what a police officer says. They do have a gun, and that makes it very, 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 very scary. And, you know, people have paid the price for disobeying an unlawful order of a police officer. But these laws need to be drawn as to what and it needs to be explicitly said as to what you need to do. And basically, a slight smell of alcohol doesn't cover it. Okay, and because with appeals, there are timelines involved, I asked Grigsby about the timeline. So here's his answer to the timeline question of how much time he's got to appeal it. Hello, control room. So what's the timeline of the appeal?
Well, I have to look for sure, but one of the counts was a misdemeanor. I know there's a requirement of 10 days to file the notice of appeal. On the gross misdemeanor, I think it's 90 days after sentencing, but we're going to do it this week just to get the process expedited.
And to me, this just changed, as my understanding. For a misdemeanor, you used to have the full 90 days, and I believe they just changed it to the 10 days. I don't understand it. If your constitutional rights are violated, why shouldn't you have the full 90 days to do the legal work, get the time to get the work done, and get the appeal in? It doesn't matter whether it's a misdemeanor, or a petty misdemeanor, or a gross misdemeanor or a felony. The issue is you need time. And so what they've done is, or what they're trying to do in this process of moving it from a 90 days to get your information in, or 60 days to notify, 90 days to file the briefs, moving it down to 10 days, how many people, boy, I think my constitutional rights were violated. Now I got to get an attorney and to help out with this process, and you go, 10 days doesn't do it, you know, because of all the preparation and fighting for this. You know, I think what the idea was, if we give them 10 days, they're not going to have time to file a constitutional challenge. The attorney's not going to spend all that time. It's going to be too expensive because of the short window span and all the research that needs to be done in that short window span, and it's just knocking off the appeals. I think this is a great disservice to justice by moving it to that 10-day window. But as you heard Stephen Grigsby, this process has gone on for over a year. Research on this one is already done. They just need to put the final touches on. They're going to get, even though they have 90 days on one of them, 10 days on another, they're going to get it all done by the end of the 10 days, get it in, and get it done. All right, let's go to the next question that I ask here. It seemed to be there was some debating contention over the issue of the 30-day monitoring, electronic monitoring.
Well,
is that standard for a misdemeanor or petty misdemeanor, or did it have anything to do with the DUI?
No. No, it had to do with the fact that she was convicted of two different counts. One was in fact a gross misdemeanor, the other one was a misdemeanor. I think if a person had been convicted of either one or the other but not both, and I think the law supports the notion that they are really two independent acts that could be sentenced potentially consecutively, that given that I don't think the judge's sentence in this case was disproportionate to what was before the court in sentencing.
All right, this was interesting. And this really bothered me. You had the prosecutor. Here's what Michelle was sentenced to, okay? She was sentenced to 2 years probation, 365 days in jail, which was stayed, and which means it's out there. You misbehave, you got same or similar stuff, we can throw you in jail for that 365 days. It means that, so I mean, that's what stayed means. You got the sentence of a year. We're not doing it. We're going to give you 30 days electronic monitoring, and my understanding was there's no restrictions on the electronic monitoring, but they just wanted to know where she was for 30 days. 2 days already for time served, so it ended up being 28 days. And then a $350 fine plus court costs should be about another $80, and then plus probation fees was $342, so somewhere around $750 total fines in this. But what was really fascinating about this is that the prosecutor, now Michelle MacDonald was found not guilty of what she was arrested for. DUI, she was charged with DUI. Found not guilty of that, but the prosecutor wanted to go through chemical evaluation, wanted to go through more psychological evaluation, wanted her to not be able to drink at all, and was he asking for other sanctions against her, taking other classes. One of the classes, and to make a victim impact statement because of who she harmed in this arrest. Of course, the question was, who did she harm? And of course, if you're looking at it, you can say, okay, potentially it was the police officers that were harmed. So she'd have to do a victim impact statement to how it affect the police officers. But it was the police officers who were violating her constitutional rights, which is, this is all under appeal. There's one more thing she was asked to do that we're going to get to later. But I was really surprised that the prosecutor was doing this. And in my opinion, this prosecutor was beyond his bounds. I couldn't believe it. So I asked, is that unusual that a prosecutor does this? So let's hear the next question. Standard process. Otherwise, before electronic monitoring, she'd spend that 30 days in jail.
Well, the judge has a lot of options. They could have given her 30 days in jail. They could have given her up to the 365 ultimately for the gross misdemeanor, and the 90 days for the misdemeanor. But the practice, and there has to be some sort of regularity in the practice, is not to, for a first-time person who spent her entire 53 years with no crime at all. This is a reasonable sentence.
We're running back and forth here because I forgot to get a video ready and getting it squared up. So anyway, some things that happen is you're a celebrity or whatever, you get a lenient sentence or you get too harsh a sentence. So that's why I asked the question, is this a realistic sentence? And he said it was. And it seemed to me to be, because a first-time offender, nothing wrong. That's the way it is. Okay, let's see the next video. Next question. Oh, we got some time here? Okay, here we go.
In the technical sense that each crime has different facts and circumstances, and each individual has different qualities and factors that are relevant to the sentencing. In this case, I don't see that the sentence was disproportionate to what the court had before her. But to answer your question about the DWI, there was a recommendation for terms of probation that would have reflected the consumption of alcohol, and the court declined to impose those. So the court was abiding strictly by the jury verdict.
All right. I won't have to run back and forth anymore. Yes, the court did not apply a penalty to something she was not convicted of. Only the right thing to do, but I was just wondering what's going on in that prosecutor's head to even try that. Is it something he could say, well, she should have gotten this, but, the judge was lenient, so judge took away those two, which she should have never, MacDonald should have never had against her. And then it makes it look like the judge was being fair. Well, it is being fair, but it isn't giving less of a sentence than she may have deserved or not. But then what it enables is a judge to add on more of a requirement than is necessary in other areas. Well, I took away these three things, but I'm leaving this one. Well, this one doesn't apply either. So there are classes which is called a safe driving class. And MacDonald was ordered to take the safe driving class. And so I want you to see why, and the reason the judge gave that was, well, it's just a good class to take and everybody should take it. Everybody benefits that takes it. Really, is that the standard that we have? Yeah, you weren't driving bad or anything, but take it anyway. I'm ordering you. That's not right. That's totally wrong. That might, hey, people, go take the safe driving class. It's up to you. But not in this situation. So we're going to show the video of Michelle MacDonald's driving arrest, and you tell me if she was driving unsafe. So let's watch that. In the stop, Rosemont Police Officer Alex Eckstein, badge 3540, pulls Michelle MacDonald over for speeding in 39 in the 30-mile-per-hour zone. This is a legitimate stop because of Michelle MacDonald's driving was so bad she was arrested for careless, reckless driving. Really? Let's watch. Reckless or careless driving, any person who drives any vehicle in such a manner as to indicate a willful or wanton disregard of the safety of persons or property is guilty of reckless driving, and such a reckless driving is a misdemeanor. Well, you decide. Who was she harming? And then careless driving in a manner that endangers or is likely to endanger any property or any person, including the driver or passengers. And we're just setting up the video here. There's no sound at this point. Police officers, she's already gone by. The police officer's pulling around. And watch her driving right down the middle of the road. Not even close to either side, staying right in the middle, one side or the other, going around a corner, doing fine. Okay.
Northbound 3 here. I'm currently going 40. The car is pulling on me.
Okay, nothing. Driving looks good. A cat's going to come in the road up here.
Minnesota license plate.
29 for 140th Street.
Real fine.
39 and a 30.
29, 27 in the back, 80.
42
and
and a 30.
For about 20 minutes ago, broken. Came in through the sliding door and then at NCIC.
NCIC clear.
This is 20 minutes ago. Affirmative.
Okay, no problem. You're watching a long time. There's nothing. I mean, I'm in cars all the time, buses, and they do worse. There comes the cat. Oh, brake a little, move over to the right.
Cat in the road.
Officer acknowledges it. Then it's after that adjustment there, that she pulls close to the left-hand
NCIC
to the
clear.
yellow line on the left. Touches it, maybe, can't really tell, but does not cross over the center line. It's important to note.
35, 40, 10, 38.
There she touches it, does not cross over.
3540.
3 on air.
It's close again.
That's right.
Three
You
on
know,
air.
probably looking in the rearview mirror, somebody's following her. There's the lights, pulls over to the right, touches the right line,
8 to 9.
and
28, 5,
Stop. All right, that's good. We can come back to me. Okay, there's what you got is your careless driving. And so because of that, and the judge saw that, there's nothing wrong there. The judge ordered her to take a safe driving class. It's just outrageous. Of course, that's more money for the system, the people that teach the class. Michelle has to pay for that. And, you know, then be aware of the dangers of driving for what? Cats. Police officer said, yeah, she should have not broke, put on the brakes any, should not have swerved, should have ran over the cat. And there's a reality to that, but you don't criminalize that, a natural, normal behavior that anybody does. Now, 2 weeks ago, when I showed October 30th, you go watch the show on youtube.com/speechlessmn, look at the October 30th show. We go through that video. An amazing thing happened on our way out of the studio. One of the control room people, we were driving to where we go eat pizza after the show, and we turn around the corner and a deer pops out. And if that deer went straight, it would have ran right into us. If it stopped, we would have hit it. But at the last second, it just jumped back into the woods there. But what the driver did instinctively was brake and pull to the left because the deer was coming out from the right. We would have hit it. And I said, Dallas, I didn't mean to say his name, you must be drunk driving right now because you avoided the deer. You did natural instincts. And to then go and say that's a sign of drunk driving is ridiculous. For what she did there, that was a normal, natural reaction, unbelievable. But now she's got to take this safe driving course. And to me, the judge was beyond her bounds in that. Shouldn't have done that. She knows better. Will be under appeal in this situation. Okay, let's go to the next video there. We got a lot of video to go through. You're actually wanting those?
Yes.
But leaving them up to the court to decide?
Surprised only in the sense there wasn't a basis in the record for it, not surprised in the sense that prosecutors tend to try to affect public policy by their sentencing recommendations and oftentimes disregard, certain legal technicalities such as the one I cited, namely Blakely, which is a case that says the right to a jury trial includes the right to be sentenced only on those facts that are proven beyond a reasonable doubt to a jury.
Okay, and that gets into that discussion of this extra stuff that was being piled on. And you can only be sentenced for stuff that's you've actually done, not stuff you haven't done. And that was part of that discussion. Okay, let's go to the next question. And I felt that when I was hearing you argue that why did you even have to argue that? Because it should have been, the prosecutor should have known that, shouldn't have tried to go for, extra stuff that he knew wouldn't apply.
True. One of the problems is that there's no standardization or regulation of probation officers. None of these people are licensed. None of these people have a standardized methodology, and they are not legal scholars. So what they essentially had done was sort of disregarded the acquittal on the driving under the influence and asked for a sentence as if she had in fact been convicted of it. And probation does this to some degree because they're simply unfamiliar with the law and are simply following some sort of arbitrary standard procedure that they use customarily.
Before they went into the courtroom, Michelle looked at the police report, the probation officer report. They make recommendations as to what the penalty should be, what the person needs to do. And Michelle really argued that, hey, look, I didn't cross the line. This is wrong. And there's other facts that brought up in the court case that were wrong, but there was probation officers and the people that recommend the sentences based on past history, based on circumstances, you know, what the level of sentence should be. And this was very, very light that she got because of her history and not likely to reoffend. But they threw all this stuff in on drunk driving that would apply to a drunk driver, and she wasn't. So, I mean, that's an interesting comment he makes about these people who aren't licensed and weren't at the case, don't know what's going on, and they're throwing in stuff that didn't even apply to the case. But they have their protocol that they do. So you got to watch them if you're being convicted. And you got to appeal that stuff then too. Well, do you just do the little bit that they're asking for anyway and not spend the money? Nah, you know, we got to have a form of checks and balances. And of course, that's what Michelle MacDonald is about, is exposing the checks and balances that need to take place, that aren't taking place in our court system. And that conversation is going to come up in a little bit too. All right, let's show the next video then. Before the sentencing, this is one of my pet peeves. You and the prosecutor went before the judge and had a conversation, which I think should be open to the public to hear that conversation because it's affecting the outcome. Decisions are being made, conversations take place. What was that conversation about?
Well, that was about a technical issue of the law, about whether or not the judge actually had to adjudicate her guilty of both of the counts, or whether they merged, or precisely what it was a rehearsal of what the procedure was supposed to do. It was something that was done informally because there was no dispute about it, and had there been any kind of contention or dispute, that would have been placed on the record, but it was just an informal conference about soliciting our input about a technical dimension of sentencing.
You know, I really appreciate Stephen Grigsby, Michelle's attorney, for opening these questions and answering them in a honest way. And so he may say that, you know, they weren't disagreed upon, but we don't know that. We don't know what the conversation would be. And I think I asked him a follow-up question here, so we'll go to the next question, is basically how do we know that? And, well, let's watch it and then I'll comment on it. See this in some civil cases, that if the penalty ends up being less than, if you're charged with a misdemeanor and the penalty ends up being a petty misdemeanor, that even though you're convicted of the misdemeanor, but the penalty is less than a misdemeanor, financially, whatever, that it shows on the record as a petty misdemeanor.
Correct.
Is that, in this case, did that apply at all?
No, it didn't apply. The rule is clear. The rule is that it's the level of sentence that determines the level of conviction. And on a petty misdemeanor, there can be no electronic home monitoring or any other restriction of a person's liberty. It is purely a fine-driven penalty. But because here the judge imposed electronic home monitoring, she sentenced it within the parameters, and with the probationary term of 365 days, she sentenced it within the parameters of a gross misdemeanor and a misdemeanor.
Okay. All right. Since there was a sentence within the parameters of a gross misdemeanor, so therefore none of the charges were reduced. But if the judge would have said, you know what, we're not going to do the 365. That gross misdemeanor could have been, because the penalty was less, could have been reduced to a misdemeanor. And you see this happen especially in tickets, driving cases that may reach the level of misdemeanor. The fines may end up being only petty. It ends up being a petty misdemeanor. Now, what happens, this interesting fact, I know this for sure, if you have a misdemeanor going against you in a traffic situation and you do a constitutional challenge, that means you get a jury trial. You can ask for a jury, you get a public defender, and there's a whole lot of things you get at the misdemeanor level. Well, and especially if you're going to challenge the system, what they'll do then is then just drop it down to a petty where you don't get a public defender. So a petty misdemeanor, no public defender, misdemeanor, public defender, and if you push them, they'll just drop it to a petty so that you won't challenge the system and use the public defender. It's a game that gets played out there, and especially if you're trying to do a constitutional challenge on the misdemeanor, you want legal help, and you want somebody that will do it. And there are public defenders that will do it. Very few in the inner circle here, mostly from outstate, they'll do it. But inside the Twin Cities area, you find it that they won't do that. So that's a game that gets played in the process. In the previous video, the point of being able to get, well, I forgot what my point was. Oh, well, I thought there'd be another video on this, but I guess not. Let's go to the next video again. Is that going to be part of the appeal?
Yes.
Okay. All right. Michelle, do you have any statement? Or?
I'm just going to say, isn't he eloquent?
Yeah.
The words that come out of his mouth and what he said about liberties. You know, we're not at liberty to harm anyone. No, we're not. And you know what I said in there is that I'm a woman and I didn't harm anyone. And you put it well when you used some other words about harming versus just breaking the law.
Malum in se and malum prohibitum.
Explain the difference.
Malum in se is when you harm somebody, you hurt somebody. This doesn't require a law to suggest the illicit character of it. This is what the law is meant to do, prevent people from being harmed. Now, there's malum, and malum in se just means bad in itself from Latin. Malum prohibitum just means a prohibited bad, meaning it's not bad in itself. It wouldn't be intuitive or obvious. It would just simply be an illegality. And those things are subject to change over time. And as the argument I made, both two states now have declared that the very legal scheme under which she was convicted to be an unconstitutional act of the legislature, to essentially punish somebody for refusing to provide evidence against themselves. It's the only crime of its kind. That you can be convicted of simply not providing evidence against yourself.
On the DWI.
On a DWI, correct.
So.
Or a non-DWI, as in my case.
Well, but the thing is,
I mean, that's the point.
the law
That's the
doesn't.
point.
The legal principle that allows that statute to be upheld would not necessarily only apply to DWI. There wouldn't be any reason to do that. That legal principle would allow the act of the legislature through its act to criminalize any attempt to not provide evidence against yourself. Such as a search warrant. You know, it would obviate the requirement of a search warrant. You would just punish somebody for making the cops go to the judge and get a search warrant to obtain the evidence. They would tell you to go to your house, search it, and then they could follow up and punish you for not searching well enough. I mean, it's absurd. Mm-hmm. And it's driven exclusively by those bored housewives that join up with MAD because their husbands are making the money to give them the boredom to pursue these trivial issues.
And part of the misconception is that, you know, we have to prove our innocence by, you know, if there's a wrongful stop, as in my case, somebody asks something that they don't have probable cause for, because I was driving pretty much impeccably, I could have just, if he had offered it at the scene, taken a breathalyzer and proved my innocence. But that isn't our system of justice. It's the other way around. They have to prove
They have
guilt.
to prove the guilt.
Right.
You don't have to prove the innocent, and that's what goes on here.
Right, but the way it's changing, and I've noticed a very distinct culture in the jurisprudence at all levels of the district courts and the appellate courts, is that people now are placing the principles of liberty as second to the interests of public safety. That's what's happening, and that is I'm finding it much more difficult these days to persuade the court that implicit in the system of justice, the system's founded upon individual liberty, the primary value is liberty, and that's going to require a toleration of a little bit of danger. That a free society is a dangerous society. There are societies that are have very, very low crime rates, and they have also very, very little liberty.
Which, this is interesting. I think that was a fascinating discussion that took place there. The issue here, you got to provide evidence against yourself in DWI cases, and the attorney, which is unconstitutional, by all means, 2 states have ruled it unconstitutional. Now there's going to be a challenge in Minnesota based on this case. And then the second aspect is that this issue that you have to prove that you're innocent. And this comes into effect because there was a man, John Cummings, founders of Minnesotans for Safe Driving, which is a good group. We should have safe driving. It's a victims advocate group, and it's focused on the dangers of drinking and driving. And he was at the trial and at the sentencing hearing, and his statement, according to Michael Brodkorp's blog with the Star Tribune, said, "We have these laws for a reason, and if MacDonald would have just taken the test, we could have avoided all of this." And Cummings added that MacDonald showed horrible judgment. "I don't think anybody with judgment like that should ever sit on the Supreme Court or any kind of judicial bench." However, this is what they were talking about. This is, in this press conference, this is backwards. You don't have to prove your guilt or your innocence. It's up to the state. And they use the name of public safety to take away your liberties. And there'll probably be a little bit more discussion on that in the, later on here. But it's that mindset. Yes, John Cummings went through a horrific situation in his family where his son was killed by a drunk driver. But it was that drunk driver who did it, not somebody who wasn't drunk. And so you don't go around penalizing people who aren't drunk, make them prove that they're not drunk. You can't do that. Otherwise, what we have in Minnesota right now, because of this case and the way Judge Leslie Metzen, whose brother-in-law is State Senator Metzen, came into the situation and the way she behaved in the courtroom. There are tons of appeal process going on in this case. And so it's all backwards when it refers to your rights as a driver and having to provide evidence against you when the police officers don't have any evidence, reasonable suspicion, or probable cause in the first place to make her do a test or make her get out of the car. And she knew that as an attorney. So just because you've been harmed by somebody who did something wrong, you write a law that criminalizes, and we have, drunk driving and the effect that that has on other people. And this is one thing that Michelle MacDonald said in her, Judge Metzen said, we got a right to address the court. You have a right, Michelle, to address the court. So Michelle did. And she says, look, I was caught for speeding. I have not harmed anyone. Nobody was harmed in this deal. I've only had a watercraft violation and a parking ticket over the last how many years been able to drive. I apologized for speeding immediately. I misunderstood that I wasn't a reserve officer but had taken the citizens class, which is the first step before you become a reserve officer. And the other thing, I asked to go straight before a judge. 169.91, it says I get immediate judicial review, and I wasn't given that. And of course, that was a straight statement to the judge, because this is an appealed issue that will be appealed, is that Michelle asked to go straight before a judge, and 169.91 says you get to, and especially in this situation, and the police officers refused, and they mocked her. You can't do that. And Judge Metzen said, you can't bring that up in this courtroom. You can't provide that as a defense. And you know what? That was a backroom deal. And even when coming out of the back room, this is what I was trying to remember early in the show, when coming out of that back room, they do their conversation. It's not on film. You don't see the decisions that are being made. You don't hear them. And so coming out of that back room, you know, the judge says, well, we had some talks in the back room and we agreed to this. And this is how we're going to do the jury's instructions. And then Stephen Grigsby gets up there and says, you know, it's been agreed to with the objections that I've raised, and we'll challenge constitutionally. You know, and so there's a judge trying to intimidate an attorney saying, we've agreed to this, when there was no agreement. The agreement, okay, there was an agreement. The agreement was this. This is what I'm going to do, Mr. Grigsby. Of course, I don't know, but I heard of conversations in the back room. This is what I'm going to do. If you're going to disagree, we're going to agree that this is what's going to take place. I don't want to hear anything about it. And if you don't like it, you know, state your objection there in the courtroom. But when that happened in the courtroom twice, the situation was, we agreed to this. The judge said, we come to agreement. All nice and pretty, you know, smiley face, Stephen Grigsby, you know, with my objections, Your Honor. Yes, with your objections. What was that about? We heard nothing. There was nothing on the public record as to what that was about. No, none of the press heard it. None of the press knows what it is. I know because I asked questions. I had an idea. One was that 169.91. You can't mention that. And if the other side asked the question, and it happened in the courtroom, and I wish you could have saw it. You should have seen it, because then you'd be able to figure it out. The prosecutor says, now, Michelle asked to go before a judge, and why wouldn't you let her? And the answer was, because she can't. Unbelievable. Okay, let's show the next video here. And so she said what she did, how responsible was, went straight to the hospital, and once they let her go, blew a 0-0, they wouldn't take her in front of a judge. I have not requested special treatment, and I don't believe there is special privilege. I want to be treated just like anybody else. I have done the psychological evaluations, came out fine, came out good. You know, so that was her statement. And the judge said, you may have not harmed anybody, but your behavior was harmful to yourself and your reputation. You may have suffered because of this, but it's your behavior that caused it, which I think was just out of line. A lot of this is the police officer's behavior. She did nothing wrong, nothing. All right, let's see the next video here before we...
Societies, up until the founding of the United States with the Constitution, have always preferred the protection of the sovereign above anything else. The whole entire break from that schema with the Constitution was to give individuals the liberties over the power of society. Now, there has to be some balance, but the problem is that people now are inverting the paradigm and placing public safety over individual liberty. And it doesn't seem as patently clear in these drunk driving cases, because generally nobody is going to, you know, mount a strong pathos in favor of the right to drive drunk. But that's not really the issue. It does come about when you realize that if you place public safety over liberty, there are going to be innocent people convicted, because they're lowering the threshold of what it takes to prove a crime. The whole notion of proof beyond a reasonable doubt is designed to do one thing: make convicting innocent people impossible. And even that doesn't work all the time. But it's essentially, the jurisprudence essentially lowered the standard, and now starts finding people guilty, because if they may be guilty, they may be a danger, and that's more important than the individual liberty.
And in my case, even if you're found not guilty, they're still asking for, you had
punishment.
the prosecutor today asking for punishment, and also.
All right, we're out of time. I got to give the control room time there to do the closing. We'll show that video next week because, we won't show it. Here's the bottom line, in that Stephen Grigsby rightly puts himself at risk for saying, hey, there's a problem in our appellate courts, Minnesota appellate court, Supreme Court. They're not doing jobs of holding these district court judges accountable. And he's done a lot of appeals, and in these appeals, the judges at the appellate court level, when these district court judges mess up, they're not overturning their decisions, therefore things aren't being dealt with. All right, remember, if you don't stand up for other people's liberties, who's going to stand up for yours? And good men don't do nothing. God bless, have a great week.
You said to me that you wouldn't leave, but now I see that you're lost.